Good evening. So, I am Ed Ryan. I am by trade an intellectual property attorney. I mostly do patent work. But this is a talk about trade secret law, which is kind of the complement to patents. So, since I'm a lawyer, there are certain standard disclaimers. I am not your lawyer, and there is exactly one piece of legal advice that I will give you in this entire talk, which is do not crime. The remainder of the talk is not legal advice in any way. Even if you ask me a question and I answer it, it is not intended to be legal advice. It's just an academic exploration of the topic of trade secrets. And towards that end, if you ask a question and it has to do with a specific set of circumstances, please frame it as a hypothetical and don't use the first person. Because this is recorded and streamed, and I don't want you to get in trouble. So the basic thrust of this talk, trade secrets are a kind of intellectual property, similar in certain ways to patents, trademarks, copyrights, but they have some really weird properties that will come out to you because they also have an interplay with the criminal law, and search and seizure issues. As it says there, trade secret law provides for warrantless searches and seizures, which is not to say there's no due process, and it's actually pretty difficult. But that is one surprising result of misappropriating a trade secret. It is my personal opinion that the protections that trade secret law provides to trade secret owners are inadequate towards addressing potential threats from third-party intrusion, let's say. And this will become more clear as we go on, but most trade secret theft and misappropriation happens kind of within a company. An employee leaves, they take stuff with them, they get sued. It's not really designed for the rogue actor. So here's a quick comparison between trade secrets and patents, which I think most people are more familiar with. The core advantage of a trade secret over a patent is that it has an indefinite term. Whereas a patent has a fixed lifetime. If you maintain that secret and keep it well, it will stay your trade secret until the end of time. You know, Coca-Cola has had its trade secret formula for many, many, many years, and they don't show any signs of letting that go.
Are they allowed to use that for drugs as well?
Are who allowed to use it for what drugs? You know, could you do me a favor and hold it until the end so that I can keep a good flow going? Because I actually don't know how long, where I am going to land time-wise. Trade secret law requires that you make reasonable efforts to keep your secret a secret, which is to say, you know, if you leave a folder sitting on a table and somebody comes by and flips through the folder, they haven't necessarily misappropriated your trade secret because you really weren't keeping it a secret. And so the question of what is a reasonable effort depends on a lot of factors, depends on the nature of the secret, how big your company is, you know, what you can really put forth. But meanwhile, a patent just gives you an absolute monopoly, and in exchange, all of that material is published. So there is no secret, and therefore no efforts required to maintain the secret. And the next step, the trade secret, you don't have to do anything to go and get recognition for it. In fact, because it's a secret, recognition would be an issue, versus a patent, which has a lengthy and expensive application process. So what it boils down to is, in some cases, whereas patents are kind of the gold standard of intellectual property and provide, you know, extremely strong protection, trade secrets have an advantage in their long lifetime and relatively inexpensive way of maintaining them. So when we're talking about trade secret law, we're actually talking about 51 different laws. Each state has its own trade secret law. And then the federal government, as of 2016, has an updated and pretty thorough trade secret law. New York, interestingly, is one of the 2 states in the union that does not have, that does not follow the, in at least a general sense, the Uniform Trade Secret Act. Everything else is pretty much along those lines, including the Federal Defend Trade Secrets Act. So I'm going to be focusing on the federal law because, by and large, most states do conform to that. But what's going to happen is if you ever end up having to deal with this, each state is going to have its own little quirks relative to that, that federal system. And one thing to note is that the Federal Economic Espionage Act, which is much older, going back to the 90s, also plays a role, but is not really the focus of the talk. Pardon? Sorry. So here we have the definition of a trade secret. The term trade secret means, I'm leaning over because my notes aren't showing up on my computer. Okay. The first step, as I mentioned before, the trade secret owner has to take reasonable efforts to maintain that secret. And then that information that is being kept secret has to be valuable, and not just valuable, but valuable because it is secret. So that is to say, if you were, it gives you some competitive advantage that if it were released out into the world, you would no longer have that advantage, either because everybody else could do it, or because they know how you do it, it is less pertinent. And this comes up a lot in a wide variety of different kinds of information. It's not just source code or the design of some device. It comes out in like customer lists, potential prospects for salespeople, and these people, anything then, basically any kind of information that has that kind of value that you do make efforts to keep secret is considered a trade secret. And it's really important to emphasize that the secrecy of the trade secret is key. The moment that is released out into the wild, that trade secret has lost a lot of its value. And what can actually happen is, if that gets inadvertently released, you lose the ability to seek damages for somebody who misappropriates it, because at that point, the secret is no longer a secret. What ends up happening then is a lot of the lawsuits for trade secret enforcement are backwards looking. The breach has already occurred. The misappropriation has already taken place. And the trade secret owner, assuming there's even a trade secret anymore, is looking to be made whole, right? It's a civil lawsuit where they're looking for their damages. So the first example that I want to bring to your attention is one you may be familiar with, depending on how long you've been in this scene. But DeCSS was a tool that was, it was part of how, the fundamental trade secret was part of how DVDs were played. And so when the DVD standard was created, DVDs were encoded with this CSS encoding scheme in order to prevent third-party unauthorized playback. And now that made it possible for people to make software, DVD players, but you had to pay a license in order to get the authorized CSS codes. It was reverse engineered. And we'll talk more about reverse engineering later, but what ended up happening was when the person who reverse engineered it downloaded the DVD player software, they clicked on an end user license agreement that forbade them from reverse engineering. And in a sense, that created a duty that they broke when they reverse engineered it. That happened in Norway. Let's see if I had that right. Yes, the author of the software was in Norway, so that the DVD Copy Control Association had no jurisdiction over them. There was no way for them to get their money out of the Norway defendant. So what they did was they sued Americans who had reposted the DeCSS software that made it possible for anybody to write a third-party unauthorized DVD player. And that trial, well, that case lasted for several years and was eventually dismissed. It was in California. This was before the Defend Trade Secrets Act happened, so it was all based in state law. And it bounced up and down the California appeals courts until it was found that because by the time this lawsuit was instituted in California, everybody already knew about DeCSS. The cat was out of the bag. And so there was no trade secret to sue about. The DVD CCA asserted that these people who were redistributing the DeCSS software were misappropriating their trade secrets. But the courts concluded that there was actually, at that point, no trade secret left at all. So I keep using the word misappropriation. The statute actually creates a distinction between misappropriation and theft, where theft of a trade secret is criminal and misappropriation of a trade secret is civil. And they're very similar in their application. So the key of misappropriation is about the means by which this information was acquired, because there are proper means of acquiring information and there are improper means of acquiring information. And I have here, it includes theft, bribery, misrepresentation, so fraud, breach or inducement to breach of a duty to maintain secrecy, which goes to the promise that person made when they clicked on their end user license agreement, or espionage through electronic or other means, which I think is most pertinent to the current environment. But it can also mean acquiring this trade secret information when you know or had reason to know that the information was itself acquired by improper means. So this starts to establish kind of a chain, right? And goes back to the DeCSS question. Well, if the people who had reposted DeCSS known that it was acquired through improper means, were they also liable in that sense for acquiring misappropriated trade secret information? For whatever reason, the court in that case decided no, that it was enough public that the trade secret was dissolved before the misappropriation took place by those third parties. And I think that the standard of knowledge here is very interesting because it is have reason to know. And that's very different from what you find in the law a lot of time, which is known or should have known, right? Which implies a certain duty to go out and do your own homework. If it's required that you have reason to know, that means a higher standard, that, the information was on my desk, I just didn't look at it. And I think that helps create some room then for those downstream users in terms of plausible deniability. As long as nobody's screaming in their face, I stole this, they can make a credible argument that they had no reason to know that it was stolen. And that leads me into my next example, which is the more recent case of Waymo versus Uber, which brought in a lot of trade secret stuff. The general background for anyone who's not familiar is there were employees of Waymo, or Alphabet at the time, or the boundaries there are fuzzy to me. They left to start their own company, their own self-driving car company, that was within 6 months bought by Uber. My understanding is that it was a founding of a company with the explicit intention of having it immediately bought up by Uber as a matter of their negotiations. One or more of those employees left with tens of thousands of documents relating to Waymo's technology. And the way that this came to light was that one of Waymo's manufacturers came to them of their own accord and said, hey, Uber just wanted us to build this thing that looks exactly like your thing, which throws up all the red flags at Waymo and is the beginning of a lawsuit. The amount of information that came out in this trial was kind of hilarious. Lots of really sketchy conversations, people talking about shredding and destroying evidence. Laptops were wiped, and it's interesting to note that that's always a key indicator of a trade secret misappropriation when a wiped laptop turns up in one of these investigations. But I think it raises an interesting question now of who exactly did the misappropriating. The first guy, his name was Lewandowski, who left Google with all the documents. I think there's a very good argument there. You know, this all kind of got swept under the rug when it settled, but based on the evidence that had come out already, there was a pretty good argument there that he had misappropriated a substantial amount of information from Waymo. There was a quick question as to whether he owned the information, and no. When you work for an employer and you produce information for that employer in the course of your employment, generally speaking, the employer owns that information, particularly when you have an employment agreement or contract with them that says that you have these responsibilities with respect to the information. I think the more interesting question is, did Uber misappropriate trade secrets? And that goes to whether Uber knew or should have, not should have known, knew or had reason to know that Lewandowski had done this, and that whether he had brought it to Uber with him. And I think that the record was much less clear, at least by the time the case settled. And so then the next question would be, all right, let's assume there is misappropriation. What are the damages for it? The types of damages for misappropriation come down to basically two options. Actual damages or a reasonable royalty. And I find the reasonable royalty option kind of interesting because it's basically, so let's talk about actual damages first. Actual damages refer to the losses in value caused by the divulging of this trade secret. So if you've got some valuable secret information, now everybody knows it. You've lost your competitive advantage, whatever it was that secret provided you. And it also provides for recouping the unjust enrichment by the misappropriator. So somebody steals your trade secret, they go off and they make your thing, and they're making their own profits on your thing. You would be able to get back that unjust enrichment that they otherwise would not have gotten if they hadn't taken your trade secret. Whereas a reasonable royalty, and these are alternatives, it's only one or the other, actual damages or a reasonable royalty. A reasonable royalty comes out with like, now we're friends. Now we have a business relationship and I am paying you for something and able to go on and continue to make it. Which, you know, comes up a lot in the patent world as well. But in this case, where there was kind of a clear bad act, let's say, I find that to be an odd remedy because now these people have an ongoing relationship. And then there's also one more quirk, which is when the misappropriation is willful and malicious, and who knows what that means. It's not a question of level of proof. It's got to do with whatever was done to misappropriate. It deals with the acts, the improper means of the misappropriation. So maybe it's like, you know, you went in there with a crowbar and got the trade secret. That would be cause for double damages. Short of that, I really don't know what that implies. So now that we've got a good framework for understanding the basics of trade secrets, I think that one of the more interesting applications that comes out of the Defend Trade Secrets Act, the federal act, comes to civil seizures. And this is what I referred to earlier when I talked about warrantless search and seizure, which if you are, up on your constitutional law, sounds like a problem with the Fourth Amendment, where...
It's like I'm killing people that come to my house.
So in extreme situations, and usually where the further disclosure can still be prevented, it's possible to get a court order that allows, federal law enforcement to enter your home and retrieve whatever equipment or documents are involved in this misappropriation. It's a very rare remedy, and I think there were only five that have happened since this act was signed in 2016. If we have time later, I've got a pretty detailed set of slides that go into exactly what is required, but it is a high bar to meet, and generally requires like some kind of activity, some special kind of activity that makes the court think, oh, we need to get this stuff right now. So here are some examples. In one case, the target ignored the court orders that were sent to him. I believe the details were that he was depressed from having been terminated at his job and was not leaving his house. In another, the target was, he was just lying to the other side and to the court, and so that kind of behavior annoys courts. And then in yet another one, the target had made an overt threat regarding the trade secret information. And so in all of these cases, right, there's something there that makes the court feel like we can't just wait for this to play out through its normal processes. And all of that sounds like a very criminal kind of situation, but the civil seizure is a civil process. There is a criminal side to all of this, which comes out of originally the Economic Espionage Act. In this situation, the trade secret has to be for something that's involved with interstate commerce. So it's not enough, interestingly, to misappropriate over state lines. It has to do with the content of the information, right? So if I have, if my trade secret that we're looking at here is a list of customers, and all those lists of customers are in New York State, and somebody steals it from me in New York State, I can't go to the federal level and use the Economic Espionage Act for criminal restitution. It also has to be to the economic benefit of someone who is not the owner, and with the knowledge that it will injure the owner through this misappropriation. And I think that one in particular is key. It says that the profit motive is required in order to make this a criminal event. And if we're going to look at the criminal penalties that are possible, in general, we're talking about a fine that's not defined in the statute, and prison for up to 10 years, which is a very heavy felony as these things go. Then if it's done for a foreign agent, which is to say a foreign government or some other kind of foreign power, the penalties go up. It's a fine of up to $5 million and prison for up to 15 years. So I'm going to go back and say, do not crime. Now, when we're talking about misappropriation and we're talking about the improper means involved, there are some exceptions to all of this. And the first one is reverse engineering. Reverse engineering, as I'm sure you all know, is when you take an existing product and you figure out how it worked. Now, that product may be, a widget on your desk, it may be a piece of software, but for whatever reason now, the person who made that product believes that you have taken their trade secret by figuring it out. The fact that you reverse engineered it from the actual thing takes it outside the realm of improper means. Similarly, if you re-derived it all from scratch, that would be another example of proper means. And then in certain jurisdictions within the United States, they go even further by saying that if it's reverse engineerable, there's no trade secret to be had there. And there are court decisions that say essentially that even though this person used improper means to get the information, the fact that there was a product on the market that could be reverse engineered was enough to defeat the trade secret lawsuit. And in some cases, the court actually said the moment you sell a product at all, although it might be very difficult to reverse engineer, it would be reverse engineerable. And in those jurisdictions, then, the sale of that product destroys the trade secret. Because the logic is that that skilled person can go out and do their homework and put all of that information together. The question of whether something is readily ascertainable is really a question of fact, though. And in most jurisdictions, they take a more nuanced approach to it in figuring out what does readily ascertainable mean, and this kind of blanket exception for potentially reverse engineerable doesn't apply. The other prominent exception is the whistleblower exception, which grants immunity from trade secret actions if the disclosure is made to a government agent and solely for the purpose of reporting or investigating a suspected violation of law. And so that kind of takes us out of the realm of your Snowdens and your Chelsea Mannings, because those were not made to a government agent. It may have been for the purpose of revealing, with the intent of revealing what they saw as misdeeds. But it's specifically to a government agent for the purpose of a reporting or investigating violation of a law. And if you don't have those key features, it doesn't count as whistleblowing. But I thought another interesting little tidbit that comes out of this is that employers are required to tell their employees about the whistleblowing immunity. And I haven't found anything limiting that. There may be, decisions or other rules that limit that, but my understanding, just based on the bare reading of the statute, is that every employer is therefore required to tell their employees about this. So that brings us around to the question of hackers and how all of this applies to hackers. And so we're going to, because every talk kind of takes a different view on what exactly a hacker is, I'm going to give you my definition for the purpose of this talk in trade secret law. And we're going to treat the word hacker to mean someone who is pursuing an emphasis non-criminal exploration and finds a trade secret. So now this may be accidental. It may be, you are looking for one thing and you find another thing. But one way or another, you have found this trade secret, and we're going to leave aside for a moment the question of whether the Computer Crime Act was violated in accessing the machines involved. As I said earlier, most trade secret misappropriation happens by employees, either current employees or former employees. And these legal tools that we've talked about really focus on situations where you know what was taken and you know who took it. And they don't provide strong utility against a potentially anonymous person who is not necessarily trying to make money off of this trade secret themselves. It also leaves open the possibility that if you don't have that profit motive, it's difficult for, and you're not bragging about it, I should say, the downstream user has less reason to know that this was a misappropriation of a trade secret. And so it makes it very easy then to distribute this information into the wild without it incurring that downstream liability. The key then for the hacker who is trying to, let's say, liberate information or publicize something outside of the whistleblower provisions is to do so as anonymously as possible and to not tell people that this information came by an unauthorized access of someone's computer. Critically also, the lack of profit motive takes it outside of the realm of criminal penalties through the Economic Espionage Act. I just mentioned the whistleblower stuff, which I guess if you're comfortable talking to government agents and haven't broken any laws in the process, that would be a viable strategy. It also comes down to a question of investigation and difficulty in proving the case, right? So because the hacker is not directly associated with the company, that theft is much harder to trace. A lot of the times it really is, we saw you on camera walking out with a laptop, give us back the laptop. If it's a hacker with a third, a remote intrusion who is just downloading stuff over the internet, they're going to have to do a much more thorough job in figuring out exactly who that person is. So yeah, that is the ultimate thesis here, which is that a hacker who is seeking only to liberate information without necessarily trying to resell it to Russia or whichever other bad actor you'd like to imagine, the law doesn't provide a lot of effective tools for dealing with that. So that's the bulk of the talk. I do have more information as well about civil seizure. And this is going to get into what's required to get a civil seizure and the general circumstances of them. The first key point is that a civil seizure is ex parte, which is lawyer for only one side is involved. So the trade secret owner now is going to the court by themselves to make this case, and the target of the seizure has no ability to have their voice heard. It's available for extraordinary circumstances and provides for the seizure of property that is specifically necessary to prevent the propagation or dissemination of the trade secret. So this is, like I said earlier, this is a tool that trade secret holders use in order to prevent this information from getting out any further. The first requirement is that there is no other remedy that would solve this problem. In particular, because the party is planning to, or is showing that they are not going to comply with whatever due process results in. And that immediate and irreparable injury to the trade secret owner will occur. So basically, this boils down to the fact that the misappropriator is going to release this information, and if we don't stop them now, we're going to miss our chance. The harm to the, there's also a balance of harms here. The harm to the trade secret owner has to outweigh the harm to the misappropriator, and in addition has to substantially outweigh any harm to any third parties involved. So if they have to break, if they're trying to get into your apartment and they have to break through 3 doors to get there, not all of which you own, they have to make a much higher showing that this disruption, not just to you but to the people around you, is legitimate. They have to show not only that, but a likelihood of success when it eventually goes through trial. They essentially have to prove their case right off the bat and prove that, to that judge, again, without any, feedback from the other side, that they're going to win. And they have to also show that the target, they have to provide evidence that the target actually has this trade secret and kind of the nature of the material and what it's embodied in. You have to describe the objects with some specificity. You can't just say, yeah, he's got it, go get it. And we have to show that the target would destroy, move, hide, or otherwise make such matter inaccessible to the court if they had notice. Which is to say, we have to give the court a reason to believe that if we told them what we were doing, they would ruin everything. And finally, the trade secret owner cannot publicize this request, which seems a little redundant to me, but it's there in the statute. In addition to all of those stated requirements, the objects to be seized have to be described, and an expert goes along with the federal agents to make sure that the things that are taken are the things that are asked for. So in the case of computerized information, things stored on a hard drive, that expert is going to go there and make sure that the information is stored on this hard drive, and we're going to take this hard drive. Interestingly, also, the statute provides that if the seizure is improper, for whatever reason, the target then gets to sue for damages from the trade secret owner. So if they, get a little too hasty and this was, it turns out, not justified at all, they get to be compensated for that. And go. All right, so if there are any questions, I would be happy to take them. We've got a microphone in the middle of the floor. Please use that so that your question gets put on the record. And also, I can't see you, so if you're hoping that I will point to you, that's not a possibility. Yes?
John? Okay. You mentioned specifically seizure of software. How does that weigh in comparison with the recent Alice decision and the challenging now of all software-related patents that could be performed, the calculations performed by the human mind or expressions of laws of nature, and the applicability of that to basically anything that runs sequential steps in a piece of hardware?
So the short answer is there is no real relevance because this is a different area of the law. We're talking about trade secrets here versus patent law. And Alice was, the CLS Bank versus Alice decision was specifically a patent decision. And I could talk to you for hours about that. The quick answer on the patent side is that Alice did not outlaw software patents. And in fact, we get lots of software patents every day. The applicability to this situation is pretty minor because one way or the other, information that belongs to one person was misappropriated by another person. And whether that information is a list of customers or a list of software instructions, it doesn't really make a difference on this scale.
Hi.
Hello.
I have one quick procedural question on civil seizure
Sure.
and a second hypothetical question.
Okay.
Procedurally, on this civil seizure provision, what is the burden of proof on the party seeking civil seizure? Is it 51% sort of preponderance, or is there a higher standard applied for this?
That is a good question that I don't know off the top of my head. My guess is that it is a convince a judge level of proof.
Aren't they all?
And that, ultimately certain of those requirements are going, there's going to be some sloshing back and forth between the weight that those different requirements are given. If the circumstances are really egregious and, the guy is flipping off the courts, it's more likely that they will require less proof of the other the other requirements. Like in the case of the guy who just ignored the court orders that came in, eventually the court has to do something. And so even if those other requirements are not really met, the court is just going to believe the guy who's standing there versus the guy who's not and is belligerently not to the judge's eye.
And then a little more hypothetically, if I'm understanding the exceptions correctly, if this is something that a third party finds and has no reason to know was sort of illegally taken or hacked out of the trade secret holder's possession, that is accepted from this law.
Right. That would not rise to the level of misappropriation. Right. Misappropriation has two categories. It's you did it yourself. You did the misappropriating yourself. You're the dirty misappropriator, or you got it from the guy, or you got it from the guy who got it from the guy. Right. There's got to be some chain of knowledge there. Where you know or had reason to know that this stuff is dirty.
And are there cases, I guess the main question is, are there cases sort of elucidating how much knowledge needs to be had? I.e., you know, the extreme cases are pretty easy. Are there any cases on the middle ground where I found it on Pastebin and there's like some hacking team's logo on the top, but it doesn't say we stole this?
Right.
You know, are there cases talking about that kind of fuzzy line?
I don't know. I don't know if there is direct case law on the level of knowledge required. There probably is. But ultimately, that's going to be the sort of thing that's a question of fact, whether this person had enough knowledge that the jury will decide on. So it's going to be kind of tough to find instances where, let's not get too lawyerly about it. It will probably be relatively rare that you find cases directly on point for that.
Gotcha. Thanks.
Oh, great, it's my turn.
Pardon?
Oh, I don't know. Oh, great, it's my turn.
Yes.
So the gold standard you spoke of with patents means what?
Well, that's coming from a patent attorney. I like to think that patents are the best, which is an unpopular opinion around here. The
I hold secret clearance.
I don't. So you've got more secrets than I do. But
what you were saying, like before that, what you said the gold standard.
Right. So what
patents?
What I meant when I said that is that the level of protection that is provided by a patent is very strong. It is very easy to take a patent and use it.
Can pending last more because of that?
Can pending last?
Patent pending. Like patent pending last longer?
Because of what?
I don't know.
So there is an interplay there between trade secret law and the patent system, where the courts are very leery of allowing people to sort of use trade secret law to artificially extend the life of their patents. So it's basically, it boils down to, if you've been using this trade secret for decades and then it gets out, you can't suddenly file a patent for that, because that would be essentially getting all those decades plus your 20 years or of patent term.
Thank you.
Thanks. I really value this information about the state of the law. I'm also kind of concerned about how, from one point of view, the issues you've described are just a loophole that needs to be fixed in the law, I mean, you're right that with the current state of the law, I assume you're right that a hacker can liberate information, but what we've seen in other areas of the law is laws that originally just covered people in terrorist groups were extended to so-called lone wolf terrorists. And in the same way, you could see the Congress deciding that they need to extend the law to make sure that people can't just liberate trade secrets. And so that's more of a political question than a legal question. I'm trying to figure out, well, okay, as a political matter, how do we stop Congress from changing the law on this? And the only thing I can think of is maybe that we have to show that the people in Congress and in the public that liberating information like this leads to more economic benefit than keeping it bottled up in the hands of the monopolist. But it seems awkward to do that, even with the law in its current state. So I was wondering what kind of thoughts you have about that.
So I think you're right that it is a political question, and it comes down to a question of policy, and the policies go both ways, right? There is a sort of general policy, a kind of a concept of economic fairness, where if somebody goes out and creates value and keeps that value secret, and then somebody sneakily comes along and sneaks it away in a sneaky manner, we as a society have decided that we have the policy of saying you can't do that. And you shouldn't have done that, you give it back. Now, there are other policies involved, right? The fact that reverse engineering something is legitimate is a reflection of other voices coming in the other direction that say, well, okay, but this guy didn't do that. He wasn't doing anything sneaky. He wasn't being shady, so it's okay. I don't know that there's necessarily a loophole here to close. I see it as kind of a weakness that results from these competing policies, and as long as they're in tension, there's going to be some gray areas there that people can work in.
I had a quick question about when employers and employees and their children are involved. And what I'm wondering is, because anyway, day to day, you'll be talking about something that's a secret with somebody else, and say they brought a kid along with them to the meeting, or they're on the phone, or whatever the hell is going on. But you're just disclosing it to another employee of the company. They have a minor, and this minor can't be obligated to keep anything secret.
Sure.
And so, well, that's the thing is who's liable if is the company failing to keep it a secret if one of their employees overhears a phone call?
That comes down to the question of whether they were taking reasonable measures to preserve their trade secrets. And reasonable measures, like I said earlier, depends a lot on the circumstances and the kind of information involved. But I believe that a court, would find that letting kids in while you're discussing your trade secrets is probably not a reasonable security measure. Okay. A lot of the times the examples of reasonable security measures come down to limiting access to the information, being very careful about who knows it and who's allowed to know it.
The instance, the hypothetical scenario that I'm envisioning is that you're having a conference call with people in other countries, and so it's like the middle of the night. So you have employees that are at home and they're talking on a speakerphone. So should that business just not be conducted that way? Because it seems like that doesn't seem like a reasonable expectation of a business to do that either. So anyway, that was just what I was wondering about.
No, absolutely, and it's a great question. The part of what's going to come out then, when that company is proving that they used reasonable means, is they're going to show that they have a policy, and that perhaps the policy was not adhered to in this case, but that they have some track record of, here's what you're supposed to do. When you don't do it, here's what happens to you. And so the company as a whole does take reasonable means, reasonable efforts to maintain that secrecy. It does raise the question of, though, where's the misappropriation, right? Because if I'm, if let's say I'm the employee, and it's my kid, and I send my kid off to daycare, and my kid starts talking about, confidential client matters, right? And the daycare person hears that and is like, oh, that's gold, and they sell it to the National Enquirer. I don't think that daycare person has done anything wrong, because the daycare person in particular didn't use any improper means themselves and had no reason to think that the child had used improper means. So I think that ultimately that although it raises good questions about the reasonable efforts that the company is making, the specifics of your hypothetical, break down more in the improving the improper means were used. So I am out of time and out of questions. So thank you very much.